Without a warrant, DEA agents crossed multiple fences, walked up to a barn, shined their flashlights inside, and the Supreme Court still said that was completely legal.
Uh,
Put a bed out there if you are making meth in the barn, and then you'll be fine because you can say you sleep out there.
I don't think that makes it okay.
This is a nuts and bolts edition. Just the case, just the rule. Let's break it down.
Do you know anything about this Dunn case?
Done.
Mhm.
I would like it to be done.
Nice. D-U-N-N.
No.
All right. All right. These are some great names too.
This will shock the audience. I don't know a lot of cases.
This is going to be good
Uh-huh.
because, like Oliver Wendell Holmes, which is a great name for a Supreme Court justice, there's two pretty good names in here of guys that, spoiler alert, are going to be making amphetamines.
Oh,
That's Ronald Dale Dunn
Ronald Dale.
and Robert Lyle Carpenter. So these two guys were convicted by a jury of conspiring to manufacture phenylacetone and amphetamine and possessing amphetamine with the intent to distribute in the 1980s.
They were ahead of the curve
A little
in
bit
terms
ahead
of
of the
the
curve.
drug manufacturing.
Yeah, they were. So in 1980, this case stems out of DEA agents. So they find out that this guy named Carpenter is buying a whole bunch of chemicals, buying a whole bunch of equipment that is commonly used to manufacture amphetamine. So
The receipts will get you.
yeah, again, to quote the Supreme Court, it's awesome. They used a great word. They said they placed tracking, quote, beepers
No.
in some of the equipment in one of the chemical containers. So, unbeknownst to Mr. Carpenter. So Carpenter,
That's part of the investigation. They're like,
yes,
this guy's probably going to buy some more of this stuff. And
Correct.
then we're going to throw a beeper in it.
throw a beeper in it. So this guy, Carpenter goes, he picks up all of his drug manufacturing chemicals and equipment.
From his local hardware store.
Yep, as you do.
Mhm.
And he drives them to Mr. Dunn's ranch. So they send up aircraft, and aerial photographs of the ranch showed that Mr. Carpenter's truck backed up to a barn behind the ranch house. So now we're talking about the house is here and a barn is separate from
How far away?
We're going to talk about that. So the whole ranch was encircled by a perimeter fence. Okay.
Smart.
It had several interior barbed wire fences, including one
It's odd.
that surrounded the house itself, which was approximately 50 yards from the barn. So you have the house, the barn is about 60 yards away from the house. The fence, the barbed wire fence around the house is about 50 yards from the barn.
Sounds like you're describing a prison. Like several consecutive barbed wire fences.
It gets
If
worse.
that's not odd.
It gets worse. So around the barn is a wooden fence enclosing the front of the barn. And this had an open overhang, and it had locked like waist-high gates, like cattle gates. So you have all kinds of fencing and stuff in this case. So
He was just trying to clearly define his curtilage.
that's put a pin in that, listener. All right. So without a warrant,
Oh, no.
these DEA guys crossed the perimeter fence. They crossed several of the barbed wire fences. And then they crossed the wooden fence in front of the barn.
Yeah, that'll get it.
They were led there by the smell of chemicals.
Mm.
And once they got close, after hopping 1,700 fences,
Probably ripping whatever they're wearing. Barbed wire fences.
probably, they get close to the barn, they hear a motor running. So at that point, they don't go into the barn, but
Why not? You've already done everything else.
they shine a flashlight inside, and they're like, yeah, this dude's making drugs in here. So
I guess the slats are wide enough that they can see through.
yeah, they shine a flashlight in the barn.
Hmm.
So they then leave. You ready?
Oh, so they're just like, now we're good. We've seen what we need to see.
No. So the next day they go back twice
Oh,
to confirm the laboratory's presence. All right.
like it would have changed.
What's that?
It would have changed in a day.
Well, they were they were shining a flashlight, so they're looking
Working
at
on their probable cause.
Yes, exactly. Right. So after doing this now 3 times,
Third time's the charm.
they go and they get a search warrant, and they executed the search warrant. They arrest Dunn and Carpenter both. They seize the chemicals and the equipment, as well as the search warrant also encompassed the house. And so they go inside the house and they seize a whole bunch of bags of amphetamines.
Mm.
So the district court denied the motion to suppress, and so they said that it was good to go. So both Dunn and Carpenter were convicted of conspiracy to manufacture controlled substances and related offenses. So they appealed, right? And the Court of Appeals reversed. The Court of Appeals said, hold on, no. That barn was within Dunn. It was within the curtilage of Dunn's residence. So all the information that you got that led to the probable cause for your search warrant is no good.
Fruit of the poisonous barn.
Fruit of the poisonous barn. So the state's like, no, that is not curtilage. We very much disagree with you, Court of Appeals. So they petition the Supreme Court and ask for a writ of certiorari. Good. Very good.
Can you spell that?
I can. I don't know that that's beneficial to the listener, but I could spell it for you.
If I saw it right now, I'd be like,
All right.
some Latin.
So
that's something I skip over.
what do you think? What do you think the Supreme Court said? Remember?
Well, they said we haven't really defined this before.
Correct. But they have to make a decision now, right? So one of the things that we talked about considering whether or not the Supreme Court grants certiorari is, hey, this could have precedential value moving forward for officers and for other courts. So what do you think they said?
I think they said there's a lot of fences between you and
Okay.
and the outside.
How do you think that impacted their decision?
About determining what was actually curtilage, and if you have taken steps to obscure the outsider's view, and keep them out of your property, and then the government is coming in and just like, I'm just going to pass all these fences up.
So what do you think they said and done? What do you think the Supreme Court said? What do you think is the punchline?
Don't go over barbed wire fences.
So you're saying the Supreme Court said, nope, this is no good. Can't do that.
In the 80s.
Yeah.
I'd say they say knock it off.
Okay.
That's my guess.
All right. Supreme Court said this is good to go.
Oh, boy.
Supreme Court said this is absolutely good to go. And in doing this,
amount of times that they did it.
Yeah. Because the amount of times is mostly inconsequential once they determine that it's not curtilage.
You've already screwed it up once, the extra times.
No, they're saying, hey, it's not curtilage, so
okay.
It's not a thing. All right. So held.
50 yards is not curtilage, according to them.
Held. The area near the barn is not within the curtilage of the house for Fourth Amendment purposes. Extent of curtilage questions should be resolved with particular reference to the following 4 factors. Now, you have given me 3 out of those 4 thus far in the conversation off the top of your head. What are those 4 factors? In determining whether or not something is curtilage, the Supreme Court says, hey, there's 4 things you got to consider in determining whether or not it's curtilage. What are those 4 things?
Can a reasonable person be there and see what they can see from I don't know, something along those lines?
You're jumping ahead to 20.
Okay.
You're jumping ahead to 2013. Cool your jets. All right. So what are the 4 things you think the Supreme Court said in determining whether or not something's curtilage?
Is it immediately surrounding the home?
Boom. Proximity of the thing to the dwelling, right?
Okay.
So held in this case, applying the first factor to the instant case, the barn's substantial distance from the fence surrounding the house, 50 yards, and from the house itself, 60 yards, supports no inference that it should be treated as adjunct to the house. So the actual distance of whatever we're talking about from the house itself. Good. There's one thing. What else?
50 is apparently too much.
Yeah.
Was there any attempt by the owner to obscure the view?
Good. Very, very good. What steps, if any, the resident took to protect the thing from observation or access from people passing by? So the respondent in this case did little to protect the barn area from observation by those standing outside.
Yeah, once you're in 3 fences.
No, it said the ranch's fences being of the type used to corral livestock and not to ensure privacy. So
Okay.
we got the proximity.
I'm seeing like the 3-layer
Yeah, exactly.
fence.
That's exactly what it is. So we got the proximity to the house itself. We got what steps, if any, the resident took to secure the privacy of that area. There's two more things that you need to consider when determining whether or not something's curtilage. I'll give you it. All right.
Okay.
So the next one is whether the thing is within an enclosure surrounding the home. So
I don't argue that's similar.
The court said the barn did not lie within the fence surrounding the house, which plainly demarks the area that it is part and parcel of the house. But
so if he had done a better job of planning out his fencing,
possibly, right? It says, but
I'll remember that.
It stands out as a distinct and separate portion of the ranch. So we have the proximity to the dwelling, what steps, if any, the owner took to secure the privacy of that area, and whether or not the thing is within an enclosure surrounding the home. So those are three. The fourth thing is, what is that area used for? Right? So if it is used primarily as an extension of the living area, right, then yeah, it's probably curtilage. In this case,
that's another whole topic, though.
Yeah, it is. In this case,
he lives out there a lot because he's making meth.
Yes. So in this case,
so put a bed out there if you are making meth in the barn, and then you'll be fine because you can say you sleep out there.
I don't think that makes it okay.
That's not okay to make the meth, but we would look at this area very differently according to you.
So the Supreme Court said in this case that it is especially significant that the officers possessed objective data indicating that the barn was not being used as a part of the respondent's home. In that, the aerial photographs showed Carpenter's truck was backed up to the barn, apparently to unload its contents, which included the chemical container, and the officers detected strong chemical odors coming from, and they heard a motor running in the barn. So you're exactly right. It's not being used as part of the respondent's home. So what is that thing being used for?
Drugs.
Well, in this case, yes, very much so. All right. So Dunn's landmark case, right? Because now we have specific things, we have specific questions that we can ask in determining whether or not something is part of the curtilage or it defaults to the open fields doctrine that we learned about in Hester, right? Curtilage is treated just like the home. All right. So quick recap on what we've learned. Open fields, they're not curtilage.
They're not.
So we learned that in 1924 from the Hester case. So from there, we said, okay, how do we determine what is curtilage? And we moved on to United States versus Dunn in 1987. And we came up with our 4-prong test, right? 4 prongs being the proximity of the thing to the dwelling, whether or not the thing is within an enclosure surrounding the home, what the thing is being used for, and what steps, if any, the resident took to protect the thing from observation or access by people passing by.
That's the rule, and that's how the court applies it. If you want to see the full breakdown, make sure you click the video here and subscribe for more nuts and bolts editions. Thanks for watching.